We'll call the meeting to order. This is the meeting of the Oversight Board for the October 10th meeting. May I have a roll call, please?
Board members Epkarian.
Here.
Berry.
Here.
Nakasone.
Here.
Ochoa.
Here.
Sheehan.
Here.
Steger.
Here.
Chair Raggio.
Here. Let it be known that all board members are present. And the report of the Secretary, please.
The agenda for the October 10, 2012 special meeting of the Glendale Oversight Board was posted on Thursday, October 4, 2012 on the bulletin board outside City Hall.
Thank you. Minutes?
Approval of minutes for the Special Oversight Board meeting of Wednesday, August 22nd, 2012, and the regular Oversight Board meeting of Wednesday, October 3rd, 2012.
May I have a motion?
I have a correction to the minutes. It should reflect that Michael Garcia was not in attendance in the closed session.
Motion to accept the amended. Second.
I'm sorry. who's seconding?
Any discussion necessary? Seeing none, the minutes will be voted on. All those in favor?
Aye. Aye. Aye.
That's both minutes, isn't it?
Yeah, and I'll make sure to, before you leave, to do a correction on that one so that you can
All right, because I've signed them both.
Okay, yeah, I'll take it. At 3 is informational items. 3A is update on ROPS 3, and this is an oral report only.
Good afternoon, board members. At last week's meeting, we told the board we'd provide an oral report on the status of ROPS 3. We did receive a determination letter from the State Department of Finance on Monday, which was the end of their 45-day review period. And in that letter, they have determined a number of housing items as unenforceable. They've directed us to categorize some items as administrative in nature versus enforceable obligations. And lastly, our 2010 bond-funded project, they've asked us to halt and wait until the spring when we receive a finding of completion. We have 5 days to request a meet and confer with the State Department of Finance to lay out our response to their determination. And so as staff, we are preparing that meet and confer form right now, and it is due by Friday. If there are any questions, I'd be happy to take them, but that's the status of ROPS 3.
Questions?
Do we have an idea yet what we are going to be requesting to meet and confer on?
We're going to be, we don't agree with any of their determinations, and so we have code sections from AB 1484 and AB 26 that we will be citing in our letter to say this is where it says these are enforceable obligations and they're not in administrative in nature. And as to the housing items, we want them to know that in Glendale, the Housing Authority has always administered the 20% set-aside obligation. And so if we read AB 1484, those items are to be reflected on the ROPS. And so that's how we'll be handling those two items.
Thank you. Mr. Carey.
How much is being questioned by Department of Finance?
8.7 million in housing obligations. They've asked us to eliminate approximately 192,000 in what they categorize as administration, and $17 million, which is all of the bond money in our 2010 bonds.
But on the bond funds, they're saying you have to wait until you get the...
Finding of completion, correct.
Do we have any reason to think that that won't come? Is it more a formality at this point? Based on what we know.
Mr. Lanzapane.
Economic Development and Asset Management. Should note that on the positive side, everything else on the ROPS was deemed approved. So there's those items that are in dispute, and we've got rationale for asking for a meet and confer. But everything else on the ROPS, the schedule that you approved, had been is deemed an enforceable obligation and approved by the Department of Finance.
Except for these 5 items.
except for those items.
All right, thank you.
Microphone, please. Microphone, please. Your microphone's not on.
Is there any possible we can get a copy of what the Department of Finance is saying and what the response would be, so we can just have it for informational purposes?
I think that's going to be
Yes.
taken care of, isn't it?
Absolutely.
Okay. Is that all on item 3?
Unless there are further questions.
Item 4?
At 4 is action items. 4A is Director of Community Development regarding due diligence review, DDR, agreed upon procedures, AUP, for low and moderate income housing fund. At 4A1 is a resolution to review, approve, and transmit the due diligence review, agreed upon procedures for the low and moderate income housing funds.
This is a follow-up to the action you took last week, and just for the public, last week you took public comment on the due diligence review / agreed upon procedures on the low mod housing funds. And as the accountant presented last week, the fund balance that we had prior to AB 26 was a starting point. Then the auditors looked at all of the obligations that the low mod fund must be used for to fulfill those obligations, and at the end of the day, there was no balance left to be distributed to the taxing entities. And so today's action is to vote on that DDR. And there were no public comments received last week.
May I have a motion?
So moved.
Is there a second?
Second.
Discussion. So you know,
On what they went hunting for? I mean, because it's the, what did we call this again? The agreed upon procedures? I mean, what you go looking for is what you find, right? I mean, they had to craft an agreed upon procedures audit, for lack of a better term, and, you know, it is kind of what it is.
and the results are consistent, aren't they?
Yeah.
We found no exceptions as a result of the procedures.
Correct.
So if there's no further discussion, yes?
Mr. Chairman, the real intent is to identify funds that are available, and so using the state's guidelines, along with some CPAs, they said, okay, let's do these things to determine what cash balances are available to be transferred. In Glendale's case, there aren't any, and that's really the purpose of the report, not necessarily an audit that is finding what we wanted them to find.
I gathered from the audit that it was a process audit as opposed to anything else, that they're looking at procedures and process and whether we're doing things in the right way or not. Is that correct? Yeah.
Correct.
We usually, at least in my history, audits are a little different than that. But that's fine. We have a motion and a second. Roll call, please.
Who is the second?
Ron?
I second.
Okay, thanks. Board members Abkarian?
Yes.
Barry? Yes. Nakasone?
Yes.
Ochoa?
Yes.
Sheehan?
Yes.
Steger?
Yes.
And Chair Raggio.
Yes. Motion passes. Next item.
At 5 is oral communications. There was one card submitted. Discussion is limited to items within the jurisdiction of the Oversight Board. Each speaker is allowed 5 minutes. Members of the Oversight Board may question or respond to the speaker, but there will be no debate or decision. The matter may be referred to staff through the Executive Director of the Successor Agency for investigation and report.
Mr. Barry Allen.
Thank you, Mr. Chair and board members. For the record, I'm Barry Allen, Director of Ed Guardians, and I'm here today to bring your attention to the fact that the Oversight Board is not a legislative body, and therefore the Brown Act closed session exception that allows for real estate negotiations is not an option. Even if the exception did apply, it would only allow 2 topics a local agency may discuss in closed session. 1, the negotiator's authority regarding the price, and 2, the negotiator's authority regarding the terms of payment. In a closed session that may be presented later today for the purpose listed on the agenda is to amend, modify, or terminate the lease. Those items are not included in the permissible exceptions according to the Attorney General Opinion 10-206. Further, Health and Safety Code Section 34179E invokes the fact that the Oversight Board is a local entity for purposes of the Brown Act for open meetings, the Public Records Act, and the Political Reform Act. Had the legislature wanted to treat the Oversight Board as a local agency, it would not have designated them as a local entity. And the code section, H&S Code Section 34181, spells out the duties of the Oversight Board, which states, shall direct the successor agency. That does not mean go into a closed session to negotiate the lease by modification, termination, or amendment. Attorney General Opinion 10-206 says in part, but for the reasons stated, we cannot accept the view that the real estate negotiations exception permits the closed session discussion of any and all aspects of a proposed transaction that might have some effect on price and payment terms. The purpose of the exception is to protect a local agency's bargaining position, not to keep confidential its deliberations as to the wisdom of the proposed transaction. For the reasons stated, we conclude that the real estate negotiations exception to the open meeting requirements of the Brown Act permits the closed session discussion of, 1, the amount of consideration that the local agency is willing to pay or accept in exchange for the real property rights to be acquired or transferred in the particular transaction, and 2, the form, manner, and timing of how that consideration will be paid, and 3, items that are essential to arriving at the authorized price and payment terms, such that their public disclosure would be tantamount to revealing information that the exception permits to be kept confidential. For these readings, that this Oversight Board is not a legislative body, and 2, even if it were, the Brown Act precludes the closed session plan for this afternoon, which is violative of the Ralph M. Brown Act. I suggest that it is taken off calendar and then calendared for a public session to discuss and deliberate on the issues calendared for today's closed session. A copy of this statement will be provided to the clerk as a public record and to the State Department of Finance. Thank you. I'm Barry Allen.
Thank you, Mr. Allen. I'm sure legal has something to comment on that.
I believe that during the last meeting, this was actually pretty much discussed, I think, with Mr. Green, and I think he provided the policy reasons as to, this is obviously, the law in this area is very new, and I think that he actually provided the policy reasons as to why our office believes that we can, in fact, go into closed session under real property negotiations. I don't know if the board would like me to further go into it, but I think it was pretty much discussed at the last board meeting. I'm happy to do whatever the board would like.
Questions?
Has anything changed in the law over the last several days that would cause your firm to change its opinion?
It has not.
Then the advice that we were given by legal counsel last week prevails with respect to today's meeting and the closed session thereafter. Thank you. Next item.
At 6 is board member or staff comments.
Are there any? Seeing none, we'll go on to the next item.
7 is closed session. 7A is conference with real property negotiator pursuant to Government Code Section 54956.8. Request made by General Counsel, property location 212 and 216 South Brand Boulevard. Property owner, City of Glendale, to be successor agency. Negotiating parties, Oversight Board for the Glendale Successor Agency to the former redevelopment agency of the City of Glendale via General Counsel, and Museum of Neon Art. Under negotiations, amendment, modification, or termination of lease.
Thank you.
Mr. Chairman, before we go into a closed session, I believe that at the last meeting, there were two waivers. One was a waiver for Successor Agency Counsel to attend closed session, if I got my facts straight, and the other waiver was for the Successor Agency Counsel to talk with Mike Garcia afterward. Would the board continue, would you like to continue with those waivers? There's two waivers.
I believe so. Also, at that time, we invited those staff that were relevant to this, and I would assume that same process is good for today.
That's correct. I would. That's what happened last time, correct?
Yeah.
So where do we adjourn? Okay.
But before we do that, I do have some letters that I received, and I'd like to hand them out. This is on the closed session item, so I'll be giving one to the clerk and handing out the rest to the board members. These are letters of support for the Museum of Neon Art lease agreement with the agency.
Thank you.
We haven't recessed yet.
We'll go into closed session, and when we come out, we'll comment on it. We're back from closed session, and we have nothing to report. So
Move to adjourn. Oh, there's new business?
we have no new business? Okay. We are adjourned. And thank you again for coming.
And Board Member Sheehan seconded?